This group has become particularly pertinent, particularly Amendment 97A, in light of the apparent situation where the Attorney-General has displayed something less than a full commitment to the principle of the right to a jury trial. Many commentators, sadly, are leaping on the Colston 4 verdict to question the jury system and apparently seek to undermine public confidence in the principle that every person has the right to be tried by their peers. So I think this would be an ideal opportunity, and I hope the Noble Lord the Minister can reassure your Lordship's House that no matter how politically inconvenient it might be for the government, trial by jury is fundamental to our justice system, and the government remains committed to it. And that, I think, is particularly, as the Noble and Learned Lord Panic has said, 97CA is an important practical step to ensure that that remains a proper, full jury trial with the kind of interactions that your Lordship's House has heard about. Now, just very briefly, the other amendments in this group I think are particularly important to protect children and other vulnerable court users. It seems like a basic issue of justice and common sense that the court should ensure that people who appear by video link are still able to participate fully in the proceedings. And I hope that the judiciary would never allow anything contrary to this, although I do take the point from the Noble Lord Ponsonby that sometimes the practical has to override the ideal, but nonetheless it seems right that the legislation should offer these protections.
Now, the noble Lady Baroness Bennet of Manor Castle threw somewhat of a gauntlet down to me, and I'm very happy to pick it up briefly. The fact is that juries sometimes return verdicts which raise an eyebrow. But I have to tell you, from bitter experience, it's not unknown for judicial decisions to trouble the eyebrows too. And in a proper case, there is a procedure, once the jury has brought in its verdict, to ask the Court of Appeal to consider and determine specific points of law to assist in future cases without disturbing the actual jury verdict in the instant case. Now, if the noble Lady Baroness Bennet wants to have a crack at my right honourable friend, the Attorney-General, she can. But what she can't do is stand up and have a crack at her, betraying, I'm afraid, fundamental ignorance of the underlying legal principles. Counsel in the case himself said that his arguments were, quotes, new and complex, close quotes. Those are precisely the points which would be suitable for a reference under Section 36 of the Criminal Justice Act 1972, a provision with which I'm sure the noble Baroness is very familiar. I'm also sure she has read the recent case in the ECHR of Hanjinsky and Bulgaria, decided on the 6th of April 2021, which discussed in terms whether the provisions of Article 10 of the ECHR did or did not apply to a charge of criminal damage. So I'm very happy to respond as to the glories of the jury system, but I would respectfully suggest to the noble lady that if she is going to make a point about the conduct of the Attorney-General, she looks at the underlying legal position first. There are certainly points in the Colston case which an Attorney-General might properly decide to or not to refer to the Court of Appeal, and that's a matter for the Attorney-General.